To do. Kerry McCarthy.
Thank you, Mr Deputy Speaker. As indicated by my intervention earlier on, I would like to focus today on the potentially serious impact this bill will have on kinship care arrangements. I very much hope that the government will seriously engage with the concerns raised by groups like the Family Rights Group and take the opportunity to amend the bill during committee stage to address their concerns. Recent research by Bristol University estimates that around 173,200 children are being raised by family members or friends of their parents because their parents can't look after them. This equates to 1 in every 77 children in the UK, and in Bristol this rises to 1 in every 59 children. These children have often experienced tragedy or trauma in their life due to the death or imprisonment of a parent, or to a parent's alcohol or drug misuse problems or mental health problems. Sometimes the parent has simply walked out on them and disappeared. Most of these children are being raised by grandparents, but sometimes it's siblings, it's aunts, uncles, even friends or neighbours, or their parents' ex-partners who step in to help. And many of these placements occur when there's a crisis situation arises. The children benefit hugely from remaining within their wider family units and with people they know and who love them. It helps them maintain contact with family members and sometimes with their parents where this is appropriate. And this often means also that they will stay at the same school and keep in touch with their friends there. Roughly half of children go into kinship care with behavioural and emotional difficulties, but around 80% improve after placement, which is the same figure as for foster care. Despite the fact that support for family and friends carers is inadequate or non-existent, children in this care, by comparison with children in unconnected foster care, are as safe and doing as well, if not better, in relation to their health, school performance and attendance, self-esteem, social and personal relationships, and show a marked improvement in emotional and behavioural problems. Family and friends carers are more likely to be highly committed to the children in their care than unrelated foster carers, as well, of course, as to match their ethnicity, leading to more stable placements. Only an estimated 6% of children who are raised in family and friends care are actually looked after children. The majority, the huge majority, are living with their relatives and friends outside the care system, either with a parents' agreement or under a residence or special guardianship order, which they're granted by the courts. These arrangements would save the state approximately £12 billion that it would cost if the children were in independent foster care. I first became interested in this issue when I heard the story of Paul on Women's Hour a couple of years ago. He's now 26. He raised his 6 younger siblings from the age of 22, but he had to battle the system for over a year and see his brothers and sisters taken into care and put into foster homes before the court accepted that he was the best person to look after him. I was fortunate enough to meet with him at the time when I introduced a 10-minute rule bill to assist kinship carers in June 2011, and was struck by the extraordinary determination and love he'd shown towards his younger siblings and the sacrifice he'd made, obviously, in his own career and his own personal freedom to look after them. But he was adamant that he had to step up to the plate. He was the best person to look after them, and it's proved so far to be exactly the case. Clause 1 of the Children and Families Bill says that when a local authority is considering adoption for a child in the care system but are not yet authorised to place them for adoption, they must consider placing the child with a local authority foster carer who is also approved as a prospective adopter. They are no longer required to give preference to placing the child with their parents or wider family network. The Family Rights Group has undertaken detailed research into the impact of these proposals on family and friends care and has set out some very careful and reasoned amendments which I hope the government will look at. Clause 1 could potentially be applied to any looked after child, even those who are in care by agreement with the parents, despite there not having been any due legal process in which the threshold for the state to remove a child from their parents and or place the child for adoption has been fully established. In voluntary accommodation and pre-birth cases, there will not have been any legal proceedings at all. So in these circumstances, kinship carers are very unlikely to have had legal advice. The court's final decision about whether the child should be removed from their family will be preempted by the child forming attachments to the prospective adopters. Any court which later considers the case would not be able to resist the status quo argument that it is better for the child to stay with the adopters than return to their parents. And this problem is further compounded by the lack of any legal duty to work with parents to help them resolve their problems before or after the child is looked after. And this, it is suggested, will have the effect of squeezing out potentially suitable family and friends carers. The status quo argument would again militate against moving a child from the prospective adopters to a relative's home. It is vital that court decisions about whether to remove children permanently are not preempted. In addition, the government's proposals to limit the time frame for care proceedings to 26 weeks, as set out in clause 14, could be imposed at the expense of getting it right for children. I'm aware that this aspect of the government's changes to adoption has not been given a proper airing, as the debate in the media has so far been very much about the efforts to reduce the emphasis given to ethnicity, culture and so on when matching a child to an adoptive parent. But I'm slightly surprised that it has not caused more alarm amongst opposition colleagues who are normally quite exercised by the concept of an overbearing state interfering with people's lives, when this bill actually makes provision for children to be removed from their families without due legal process being observed. I also hope that not only will the government reconsider clauses 1 and 6, but will take the opportunity to introduce amendments set out by the Family Rights Group that could possibly support kinship care arrangements, and I very much hope that this is visited during the committee stage.